There are moments in history when everything shifts, when the system snaps and the words of the Constitution suddenly feel alive again. For decades, the right to carry a firearm was buried under red tape, biased judges, and good cause excuses that forced law-abiding citizens to beg for permission to defend themselves. But today, that era is over. In a historic 6-3 Supreme Court decision, the justices didn't just strike down one restrictive law, they shattered the foundation of how states limit your right to carry. This wasn't an adjustment, this was a revolution, and it's already sending shockwaves through courts, state houses, and media studios. If you've ever wondered whether your right to bear arms truly meant what it says, the Supreme Court just answered. This is Firearms Rights Advisor, where we cut through politics and give you the unfiltered legal truth about the battles shaping your freedom. Let's break down what this ruling really means, why it's far more powerful than you've been told, how states are scrambling to react, and what this victory means for you.
Chapter 1: The 6-3 decision that shook America. The gavel dropped like thunder. 6 justices in favor, 3 dissenting. But it wasn't just the numbers, it was the message. For the first time in modern history, the court stood united behind a clear constitutional majority. The ruling dismantled the idea that your right to bear arms stops at your front door. It declared that the Constitution doesn't ask for permission. It doesn't bend to a sheriff's opinion, and it doesn't wait for a bureaucrat to say approved. The right to carry is not a privilege, it's a protection. This wasn't just a case, it was a correction. The court reminded America that rights aren't negotiated, they're guaranteed.
Chapter 2: The Permit Trap, a Century of Control. To understand how monumental this decision is, we need to go back more than a century. After the Civil War, Southern states passed black codes to disarm freed slaves. In 1911, New York's Sullivan Act created the first modern permit system, a law designed not to keep people safe, but to disarm immigrants and the working class. Over time, other states copied the model, using high fees, endless delays, and vague good cause rules to keep guns out of citizens' hands. Courts looked away. Politicians called it safety, and the Second Amendment was quietly treated like a second-class right. But that century-long trap just snapped. The Supreme Court's 6-3 ruling tears through that legacy, reminding America that a right delayed is a right denied.
Chapter 3: The Bruen Effect, the Return of History. This decision didn't appear from thin air. It's the direct descendant of the Bruen case of 2022, the moment the court redefined how all gun laws must be judged. In Bruen, the justices set one standard. If a gun law isn't consistent with the text, history, and tradition of 1791 or 1868, it's unconstitutional. No more balancing tests, no more reasonable restrictions, no more hiding behind the words public safety. The new ruling builds on that foundation, but applies it with force. It's Bruen's younger, bolder cousin, the one that doesn't ask politely. The court told judges nationwide, stop inventing exceptions, start honoring the Constitution.
Chapter 4: Shockwaves across the states. The ink wasn't dry before the panic began. California rushed to rewrite its carry laws, turning entire cities into sensitive places. New York scrambled and passed the Concealed Carry Improvement Act, which critics called the Concealed Carry Removal Act. New Jersey added insurance mandates. Maryland layered on new training and delays. Meanwhile, Texas, Florida, and Georgia celebrated, using the ruling as fuel for constitutional carry. Gun rights groups, GOA, FPC, and SAF, launched a tidal wave of lawsuits overnight. Federal courts were suddenly flooded with cases, citing one line: the Second Amendment means what it says. And for the first time in decades, it's the gun control states that are on defense.
Chapter 5: The Resistance and Why It's Crumbling. Anti-gun states didn't surrender quietly. They doubled down. They expanded sensitive zones to absurd levels: parks, churches, parking lots, even entire neighborhoods. They demanded expensive insurance policies and created emergency laws to stall new applications. But every one of those tactics is falling apart because none of them existed in 1791. There were no sensitive places, no colonial insurance mandates, no British permission slips for freedom. That's why case by case, state by state, these restrictions are being struck down. The message is simple: you can't ban a right because you fear it.
Chapter 6: The New Legal Standard. Text, History, Tradition. This ruling doesn't just settle one case, it rewrites the rule book for every future gun case. Judges now have 3 tests, and only 3. Text: what does the Second Amendment actually say? History: was there a comparable law in 1791 or 1868? And tradition: did early America accept this restriction as constitutional? If not, that law falls. No balancing, no emotional arguments, no, but times have changed. This standard slices through decades of judicial activism and restores the original meaning of the Second Amendment, not as a privilege to regulate, but as a freedom to protect. Chapter 7: What this means for you. This isn't just a courtroom victory. It's a lifestyle shift for millions of Americans. Here's what changes immediately. Good cause laws are collapsing. May issue states are becoming shall issue, or even permitless. Traffic stops now presume your carry is lawful, not suspicious. Reciprocity is expanding. More states will be forced to honor each other's permits. And the burden of proof has flipped from the citizen to the state. For the first time in modern America, law-abiding citizens can carry confidently without fearing they'll be punished for exercising a right. The law no longer tolerates discrimination disguised as policy. Chapter 8: The Political Firestorm. Of course, freedom never comes quietly. Capitol Hill is already burning with backlash. Senators are proposing new workaround laws. Blue states are redefining sensitive places. And media networks are warning of chaos. But here's the truth. What they call chaos, the Constitution calls liberty. The 2026 elections will be a war of ideology. States' rights versus citizens' rights. Fear versus freedom. The court drew the line. Now the people must defend it.
Chapter 9: The Domino Effect. This ruling was about permits, but its ripples are already reaching every corner of the gun debate. Assault weapon bans being struck down. Magazine limits falling in court. Waiting periods, no historical support. Training mandates and insurance laws on thin ice. Gun owners are finally playing offense, and the courts are listening. This is the beginning of a new era, a floodgate moment in American law, where every anti-gun statute must now stand trial against the Constitution itself.
Chapter 10: A Turning Point in History. Every generation has its test. For ours, it's this. The 6-3 ruling isn't just a win, it's a restoration, a reawakening of what the founders wrote and what millions have defended for over 2 centuries. It doesn't balance your rights, it honors them. It doesn't reinterpret the Second Amendment, it restores it to its rightful place, equal to speech, religion, and every other freedom that defines America. Politicians will resist, activists will rage, but history doesn't belong to the loudest voices. It belongs to those who stand on principle. So stay informed, stay vigilant, and stay free. Because as long as you know the law, they can't take it from you. This is Firearms Rights Advisor, where we bring you the truth without spin, without fear, and without apology. Subscribe, share, and stand tall, because freedom only survives when it's defended.